Only 3% of the High Court judges appointed in the last 5 years are from scheduled caste. The recent data from Centre says. Of the 497 judges who were appointed to high courts in the last 5 years, only 16 were belonging to scheduled caste and 7 were from scheduled tribes. Law and Justice Minister Arjun Ram Meghwal, in a response to a set of query about the number of judges of SC, ST, OBC and minority communities appointed to the Supreme Court and High Courts since 2019, had informed of the social diversity in High Court judges' appointment. The minister also has said that judges in higher judiciary are appointed through recommendations from the Supreme Court Collegium and that there is no reservation for such appointments. The lack of representation of judges from different sections of the society is a reflection of the inequalities in it. The New Indian Express reached out to Retired Justice K Chandru to comment on the appointment of judges in higher judiciary.
There is no principle of reservation in the higher judiciary at any time. When somebody filed a case, Supreme Court dismissed it by saying there is no reservation in higher appointment. Then people like Justice Krishna here, who started a campaign that the higher judiciary also must be more representative of all the areas and communities in India, and conscious steps should be taken to bring in more people from the other sections of the population. He has written several letters to central government and the Prime Minister. And very lately, Supreme Court and the Supreme Court did not take note of it, but the government, before the Collegium experiment, assured Krishna in their reply that they will insist upon social justice in the higher appointment. So there were several circulars were sent. After the Collegium experiment, when Collegium, the judges themselves took complete control over appointment, completely the social justice representation completely stopped. Very recently, in appointing one scheduled tribe judge in Guwahati High Court, Supreme Court Collegium made a statement. His appointment is asset to judiciary and it will represent diversity in the appointment. That's the first recognition of Supreme Court agreeing such appointment will bring in diversity. But there is no conscious effort to bring in people from different sections of society, including MBCs and Dalits. The result is that higher caste is overrepresented in the higher judiciary and the other communities are very, very, very underrepresented. So the talk of diversity is just only a token representation. So this is just a token representation. So whenever there is a campaign, for example in Tamil Nadu, from the other section, from the civil society, there has been certain conscious decision. Therefore, at a point of time in the Madras High Court, there were 6 scheduled caste judges and more than 20% MBC candidates that were there. But some of them were from the lower judiciary, because in lower judiciary there is already reservation. Therefore, that may get bound to reflect in when they are elevated to High Court. So that should not be taken into account. We must see when there is a direct appointment to higher post, whether any conscious selections are being made or not. Now only last week, Supreme Court, in recommending 2 names from Tamil Nadu, mentioned that both of them belong to scheduled caste and MBC. This will again enhance the diversity in the appointment. Therefore, it cannot be left to the vagaries of each collegium's idea of selecting people. It should be a uniform procedure, and for which there must be standard operating procedure should be evolved. Even in other government appointment, reservation is not the solution. It's only a means to achieve the larger goal. In a society where people have been deprived of education and social status, the socially and educationally backward people have been given certain handicap to overcome their initial disability. So this is something like an affirmative action. So all can be treated equal, unequals cannot be treated equal. That is a principle. If unequals cannot be treated equal, then the people who are not equal should be given certain handicap. Therefore, it is not the solution, but certainly it's a want, because a country which has been a subcontinent, which has several cultural, several languages, several religions, and several communities, sub-communities, and hierarchy of communities in this country, unless the higher institutions are representative of all these communities, the people will not accept it as an institution which can serve social justice. There are two issues. When there are qualified candidates are available, they don't look for qualified candidates. Why? Because even among others, the collegium system has always promoted their own kith and kin all the time. Either they are sons of some senior lawyers or relatives of judges. Recently also the statistics furnished in the parliament showed that 71% has somebody already in the judiciary or already in the legal field. Therefore, the other people are being edged out. While there is a campaign to include them into the list, the functioning of the collegium system functions more of a very favoritism and nepotism. Now, as rightly pointed out by Justice Romapal, it's like a old boy club. Two old boys will recommend a third man who will become member of the Assembly Club. That's how it has become. So as long as they don't furnish the real statistics of how appointments are being done, what is the background. So sometimes in this token representation, they may even select a rotten candidate, which we have seen some of the examples. That is because there is no proper selection method. Once Krishna said, even an IID is the lowest community in Kerala. Even an appointment of an IID in the High Court in Kerala will do better service than other appointed judges. So a contempt petition was filed. And when the contempt petition, Justice Krishna gave a reply, I only meant that even in other communities, there are qualified people, but you don't have eyes to look for them. So the main problem today is the selection process should be consistent with the requirements of the office. So even among the unrepresented section, there are good lawyers, but they don't have anybody to campaign for them, anybody to look forward for them. And the collegium system operates in a very higher level, where there is no democratization, there is no decentralization. Therefore, in the result, good candidates are left out, and worst candidates get in, and then draw more bad name to the very same community. The Constitution provided for President to appoint a candidate, they should consult the Chief Justice. And in addition to that, if it is a High Court, they will consult the Governor and the Chief Minister. That's how the few sentences in the Article 217 and 124 for Supreme Court provide. But over the period, there has been by practice, both the government used to recommend name, the High Court should recommend name, and by the combined list were taken into consideration. And later, over the period, the Supreme Court, by interpreting 124 and 217, started saying, in order to have independence of judiciary, the executive interference should be stopped, and therefore, the proposal to have a name should emanate from the Chief Justice of the High Court, and then it should go to the Supreme Court. Later, they didn't believe the Chief Justice because they thought Chief Justice will be biased, or he is from outside the state always as a policy. He may not know the full details. So the collegium system was evolved, by which Chief Justice will have to automatically consult 2 and 3 of the judge. And then the Supreme Court Collegium Chief Justice of India will consult 2 and 3 of that High Court. Now, these recommendations were not actually binding on the government. Government can have their own objection. Now, government brings an objection. If the court overrules their objection, they will have to appoint on the basis of advice. Now, after some time, it was found that the Chief Justice themselves, taking note of other 2 judges, they were proposing unilaterally. Therefore, the third judgment of the Supreme Court said that it should be a written consent of the 2 and 3. Therefore, the collegium was evolved through judicial orders and not found in the Constitution. So when the Government of India brought an amendment, 99th Amendment, in which the National Judicial Appointment Commission was evolved, it had 6 members, 3 judges and 3 non-judges. Among the 3 non-judges, 1 will be the law minister and 2 will be person appointed by the Prime Minister on the advice of the Judiciary. Now, what is happening is, the Supreme Court said this 6th member is heavily in favor of executive, and therefore independence of judiciary will be impaired. Therefore, they shut down both the 99th Amendment as well as the NJAC. Now, the NJAC experiment could not go to the next stage because if the Supreme Court objection is 3 judges versus non-3 judges, is a tie. They could even make it as a 4 judges and 3 non-judges. So the Supreme Court can have a decisive say. But then the present government did not want to bring any further amendment to overcome the basis of the judgment. Mainly because collegium system functions in a secret manner. Nobody knows what is happening. It's only when a judge name comes out and the appointment stage, people come to know who he is. So we do not have a transparency in this appointment. So in my opinion, NJAC should be recreated with more representation to the judiciary. At the same time, it must have a permanent secretariat, a mechanism where anybody could even apply. Now there are no applications. Some judges will propose some lawyer's name, it may go through. Some chief judges keep on saying, I have consulted even everybody in the High Court. I have consulted down the line. I don't confine myself only to 2 and 3. That is only a tactical reason, because if they want to overcome the 2 and 3, they will go down the list and ask some other person in 4th and 5th in the list. That is only an ad hoc arrangement. We should have a standard operating procedure, a permanent secretariat, and a method of appointment already ensured, where anybody will can even put forth their candidature. And finally, the selection should be based upon social justice principles. That is my view. The judicial accountability is very much essential because we have been talking about it. There is a Bangalore principle, and in 1999, Supreme Court evolved values in higher judiciary that was made acceptable by judges by consensus. That 1999 principle was sent to all the high courts, and some of the high courts have adopted it. But then once those judges retire, the other judges don't feel anything bound by those principles. The restatement of values in judicial life. There are 90 principles, but none of the principles have ever been followed. I think it should not be left to the consensual arrangement. Therefore, everybody thought there will be a judicial accountability bill, which is still pending in the Rajya Sabha, but nobody is cared to bring it up, because once you bring it, judges may oppose. Now there are too many things are in court, they don't want to antagonize judges. Therefore, the judges escape without there being any accountability in their performance and their conduct in public life. Therefore, there are several things that take place. In fact, yesterday there is a news, Bombay High Court judge resigned in the open court, saying it is not a place for self-respect. And he did not give the reason, but the reasons are now very clear. That the Supreme Court wanted to transfer him out of Bombay High Court, only because he gave a judgment in favor of Sai Baba, who is a Maoist leader and critic, and then set aside his conviction given by the special court. And this judgment was taken exception by the intelligence department, and that report was given to the court, and the court, based upon that, wanted to transfer him, asked his opinion also whether he is agreeable to go or something like that. Instead of giving a reply to that query based upon an intelligence report, now he resigned and gone away. Now we lose one person. If the judgment is wrong, Supreme Court has granted stay of the judgment. Therefore, there is nothing. There are people who are bound to commit mistakes. But if it is a motivated judgment based on certain extraneous consideration, the proper method is to impeach that person through the method known by law. The method known by law is the initiative goes to the Parliament. Parliament brings the impeachment motion. Based upon the judges' inquiry committee, the motion is put to vote, and 2/3 members should be present and voting. If there is a majority among them, then the judge is removed from office without any benefit. But this is a very cumbersome process, because impeachment is actually become a political decision. At the same time, a judge by transfer is not going to help because there are many transfer judges. Even on the transfer places, they were misbehaving. Therefore, the transfer is not exporting corruption. So the only way is to bring in an accountability bill where shorter than impeachment, the judiciary will have power to take action against judges. That's the only way.